What happens to your stuff and your family when you're gone? There are three things that may happen depending on how you've planned. First, you have a comprehensive plan that avoids probate. In that case, your stuff will pass to your family with a minimum of time and hassles. Second, you have only a will. When you have only a will, your family can look forward to probate. You see, a will requires probate to be validated and activated. Only when a judge says that it is valid does it start to work. We'll talk more about probate in just a minute. At least with a will, you have control and decided who gets what, but your family will still face the pains of probate. Third, you have the do-nothing plan. That means you haven't done anything. With the do-nothing plan, your family faces probate only without a will to tell the court who gets what, when, how, and how much. You will have passed what's called intestate. Intestate means without a will. Now, if you aren't familiar with probate, let me tell you about it briefly. My checklist for probate has over 130 tasks, hearings, and checkpoints. First, you need to know probate is public. A judge is in charge. Your worth and assets will appear in the inventory and required accountings of the estate. Even if one person doesn't waive the right to a hearing, there will be multiple hearings in front of the judge. Your family will spend at least 8 months and possibly many years waiting for their inheritance. And by the way, their inheritance will be reduced by debt, attorney fees, taxes, and the personal representative fees. When you are intestate, that is, without a will, the state has written the rules. They have written the rules for who gets what, when, how, and how much. Let's start with your spouse and children. Most people assume their spouse gets everything. However, in Arkansas, the default rule is 1/3. Your spouse gets 1/3 and your children get 2/3. 1/3 of your personal property like money and 1/3 of your real estate in your name goes to your spouse. The money's easy to split. The bank or other financial institution will write checks and issue those to your family. Your other belongings are also split 1/3, 2/3, including cars, jewelry, clothing, and more. For real estate, your spouse only gets a life estate. This means they have use of the property for their lifetime, then it goes to your children. Your spouse's and children's names will all appear on the deed. If your spouse needs or wants to sell, then everybody whose name is on the deed will have to sign at the closing. If your spouse wants to sell, then they only get 1/3 the value of the life estate. The value of a life estate is based on life expectancy. The older your spouse gets, the less the life estate is worth. Your children get the remainder of the value of the property. If you have children receiving government benefits, they can lose their benefits almost immediately if they receive a lump sum inheritance. Without a will, you can't disown children. The rule is an even split between all your children, even if you haven't seen them in 20 years and don't want to leave them anything. It gets really complicated if you don't have children. The default rules say it goes to your parents next, and then your siblings, cousins, so forth and so on. If you wanted to leave everything to a favorite niece or nephew, the rules say otherwise. The best way to make sure that everything you have goes to who you want, when you want, how you want, and how much you want is with a plan.